Greetings and salutations. Welcome back to another episode of the Legal Beagle podcast. Today we have James the Patriot from Utah. He has been helping people wage battles against these municipality crimes for quite some time, has a lot of knowledge about what to do and how to do. Today we're going to talk about a court of law versus a court at law, which is basically administrative court versus a real court where you have constitutional right guarantees. Really enjoyed the chat here today with James, and I hope you do as well. So without further ado, here's James. And welcome, James. Thank you for being a part of the Legal Beagle podcast.
Thanks for having me. Glad to be here.
Absolutely. And what are we going to talk about today?
Oh gosh, how much time do we have? Where do we even begin, Gary? I don't even know where to start. I mean, there's just so much crap going on. I mean, it's hard enough to keep everybody up to date with everything I'm doing and all of the folks that we're helping and everything that you're doing. I don't even know. But I think one of the things that when you had reached out to me, you said, you know what should we talk about? I thought about that for a little bit. You know, at first I just gave kind of a knee-jerk reaction, but as I'm looking at this into more detail, and as I've been listening and researching to more seasoned individuals who have been doing this long before you and I were even born, it's really come to what's really come to mind is helping people to understand that when we walk into a court, we may think it is what we're seeing, but in reality, it's not. Um, there's oftentimes that court can take the form of 2, sometimes 3, even 4 different court situations, and I don't think people realize that or know that. So I don't know if you know what I'm talking about, but
Well,
that's what
let's
came to
find
mind for
out.
me.
Tell us about it.
So what comes to mind for me is this, and I'm going to pull up a couple things, and I don't need to share my screen, but I do want to show or I want to go over a couple of things. I've been, and I don't know if you have been following this at all or heard of this individual, but his name is George Gordon. You know who George Gordon is?
I don't think I've heard that name.
Yeah. So when you get a second, jump onto YouTube and search for George Gordon, and you're going to find a bunch of common law lessons that he gave back in 1986. What's fascinating is this guy knew and realized everything that we're talking about and what we're dealing with today and what we're trying to educate people on today. He knew about this back then, and he was really I guess you could say kind of a pioneer in this field, in that he was one of those guys that went and drove on the road without a license plate on his car, drove without a driver's license in his pocket, and he was willing and able to fight it. He was ready and willing and able to be arrested, to taken to jail. Happened to him numerous times. But what's fascinating about George Gordon, of the 30 something odd criminal cases that were brought against him, a lot of them were just petty misdemeanor cases. He was not convicted of one of them. He won all 30 something cases. So,
Well,
and some of them he even got, I think, as high as the United States Supreme Court. So,
and I'm assuming he had
so that's what's interesting.
less judicial activism.
Oh, yeah. Because this was back in early 80s. So I was born in 1981. And this guy was doing this from like 1977, 78 on until he passed away, I think in 2010 or 2011. I can't remember exactly. So he has a website. I always throw the website out there. It's GeorgeGordonCommonLawSchool.com. His wife, his widow, still runs it today. She sells all of the material that he has. It's not cheap. It's like $3,000 or $4,000, but it's fantastic material. You can learn so much just from listening to the recordings that he has that somebody put up on YouTube. Just search George Gordon Common Law School and you'll find it. It's super simple and easy. So
that's what I'm typing in, and nothing's coming up.
George Gordon, Gordon, Common Law School.
George
There's
K.
actually
Gordon?
a playlist that's called George Gordon, correct.
Okay, let's see. Okay. I see his LinkedIn page.
Yeah.
Anyway, I'll check that out and tell us what he's about. Where's he
Yeah.
from?
Yeah, I think you're gonna find when you start listening to it, it's fascinating information. It really is.
And
So,
where's he from?
um, so one of the things that I learned from George that I didn't realize really before then, I mean, I had been helping people in some court cases and trying to get things back to the common law system, back to the system that our founders intended, and really what should still be given all of us. Um, what I didn't realize is that there are at any court proceeding, whether it's one that you've initiated where you're the plaintiff, or one where you're being sued or being criminally tried as a defendant, each one of those courts operates according to one of two dictates. Excuse me. They're either a court at law or a court of law. Have you ever heard that phrase, Gary?
I have, and I'm hoping you're going to tell us the distinction.
Okay. Well, before I do, tell me what is your understanding between those two, a court at law and a court of law?
Well, it was previous to when they divided equity and law in the courts, from what I understand. And
There you
so
go.
when they combined them, they supposed to have become one thing, one entity. But what do you know? What do you know about it?
Hmm. You're absolutely right. I mean, what it denotes is the difference between a common law court, which is also known as a court at law, and a court of common pleas or a court of equity, which would be a court of law, one that was created by statutes, one that was created by codes and procedures and regulations, things like that. So the struggle that we, the American people, have been thrown into, either willingly or unwillingly, is our beautiful system of common law has been slowly taken away and usurped with democracy, with mob rule, with justice rule. Well, it's so much easier to prosecute people in a court of equity. It's so much easier to prosecute people with an information. Why do we want to assemble a grand jury of 24 individuals and let them investigate and determine whether or not charges should be brought? Why do we want to do all that stuff? That takes time. That takes process. We want to run people through, get as many people through here as we can, take as much of their money as we can, take as much of their substance as we can, but we can't do that in a common law court at law because that requires certain guarantees, like the
Now,
right to assistance
what
of counsel
what
of your choice.
is this? Is this leading towards administrative courts? Is that where we're headed, or is there a distinction between the
Exactly.
two?
Any Well, so there is, yes. So administrative courts, see, here's the thing I mentioned earlier. When you walk into a courtroom, whether it's a federal courtroom, a state courtroom, or even a justice courtroom, or like a city courtroom, wherever you are, when you walk into one of those courtrooms, they may actually be proceeding in one of four different ways, depending on the action that's in front of the docket. Even though the room looks exactly the same, even though the judge sits up there with a black robe, even though there's typically two adversarial people, one being the plaintiff, one being the defendant, and maybe you're being maybe you're being prosecuted. So maybe there's a prosecuting attorney, one who's there on behalf of the city or the state or whatever the case may be. See, the problem is that ensuring citizens' fundamental rights and guarantees is time consuming. It's costly. It costs a lot of money to assemble a grand jury. It costs a lot of money to assemble a jury of 12 of your peers. Not just 12 people, 12 people of your peers. See, people don't realize that back in the 1700s, when King George was throwing around all his tyranny, he was doing the exact same thing then that's happening to us now. There's no difference except 250 years. That's the only difference that's in play.
Well,
So,
let
so what
me
happens is back then. Sorry, go ahead.
real quick. Um, this is sounding a little like the path of down patriot mythologies. Can you separate that for us?
Yeah, there's no. I'm not talking about the gold fringe flag. I'm not talking about a man on the land. I'm not talking about a state national. I'm not talking about any of that garbage. What I'm talking about is a distinction between a common law court at law and an administrative or a court of equity in a court of law. It is a lot easier to prosecute people in an administrative court of equity than it is to prosecute people in a common law court at law. So the way the way you can decipher between what kind of a court you're in is going to depend on the complaint or the information that's been filed against you. So if you have been, let's say you've been criminally charged, let's say it's some type of a misdemeanor, but that misdemeanor carries, if you're convicted, 6 months in jail, right? So what is typically on that information heading as the named plaintiff? So let's just take it, for example, in the state that you're in, Gary. You're in Louisiana, correct?
Correct.
Okay. So if the state of Louisiana, and I think I just gave it away, if Louisiana is prosecuting you criminally, what's typically on that information heading? So the named plaintiff will say something along the lines of the state of Louisiana versus
Your
Gary
name.
Brown
Right.
or whoever else. Correct. Right? Did you know? Maybe you did and maybe you didn't. But the way that this was created, constitutionally speaking, is that we, the people, hold all political power, correct? According to our state's constitutions and the federal constitution.
That's what
Is
we're
that
told.
correct? Okay. All right. So we, the people, hold all political power. So the state can derive no powers unless we, the people, grant them those powers. Right?
That's right.
Is that your understanding as well, Gary?
That's what we've been taught growing up.
Okay. All right. So we, the people, in Christians, decided that we will decide if our fellow citizen should be prosecuted. And if they are prosecuted and convicted, we will decide what their punishment will be. But that's not what happens. What happens today is the almighty state, the government, has usurped that power and has taken it away from we, the people. And they are prosecuting people as if those people are creations, i.e., creatures of the state or creatures of statute. You ever hear that term, Gary?
Absolutely. Absolutely.
Happens all the
That's
time,
what a
right?
corporation is.
Yeah. If I remember your City of Central case, right? Isn't that what they did to you? They came and they said, we're from the big bad government, and we're going to confiscate your property, and we're not going to give you due process of law. We're going to violate all your rights, but we're going to do it because 300 or 400 idiots got together in a room and decided that this is what the public needs to do. And a majority of those idiots voted yay. And then a majority of another group of idiots voted yay. And then the biggest idiot of them all signed it into quote unquote law, right? Is that what happens?
All right, if you're talking about the legislature and the governor.
Exactly. Those are the idiots I'm talking about. See, the problem that has happened, and there isn't any one organization to point the finger at. It's not like you can't say, oh, it's the American Bar Association or it's the court system or any of these other things. We really can't just there's not one organization we can point the finger out. But what I can say is that we, the people, have become ignorant. We have just succumbed to the education that we've been given or the lack thereof. And we have just decided that, oh, it's a lot easier if we agree to abide by these quote unquote moral codes that are enacted into statutory law by our state's legislatures. That's really all it is. So people don't understand being prosecuted criminally or even civilly for that matter, that they have rights and that they need to demand those rights. And the Supreme Court of the United States has said you must be a belligerent claimant of your rights. When you start to listen to the George Gordon recordings, Gary, you'll see what I'm talking about. He says you must be a belligerent claimant of your rights because failure to assert a given right, what is that? That's a waiver of that right. Have you heard that before, Gary?
If you don't know or know how to protect your rights, then you have none.
You have no rights. Correct. So I want to make this distinction very clear because you see this patriot mythology crowd up there going, "Oh, I have to correct my status. I have to sign all this paperwork, and I have to go in there, and that's the straw man. You guys are prosecuting the straw man, and this and that and everything else." While there's some sliver of truth to what they're saying, the majority of what they're saying has no basis or foundation in actual law. What I mean by that is the supreme law of the land, Article 6, Clause 2 of the United States Constitution.
Well,
We need to get back to the foundations.
isn't that the beauty of disinformation?
Exactly. Take a little bit of truth and mix it with a bunch of lies so people get hooked on that little bit of truth and then they're just off in the weeds. And that's what happens. I mean, how many times have we seen it, Gary, in the Telegram groups where people post, "Oh, I claimed my status and I went into court and I said this vessel is lost at sea." Have you heard that argument before?
Once or twice.
I just shake my head and I'm like, I live in Utah. The ocean is to drive there. The ocean is 20 hours from me. I am nowhere close to the sea. So I don't know what you're talking about with this whole I'm a free man on the land and all of these things and all that stuff. And even so, I mean, we look at it today that the FBI sent out a directive to all the federal courts that if people come into court claiming this stuff, they're domestic terrorists. See, the problem is there's a sliver of truth of what they're saying. They're saying I want my government to protect my rights, but they're going about it completely wrong, and they don't understand what they should be doing
and
to do
and
it
it's
correctly.
something the government should be doing properly anyway. We
Exactly.
we shouldn't have to tell them how to do their job, which is to protect our rights. But unfortunately, we've let
Correct.
it go too far, and here we are.
Here we are. So what happens is I would say if you were to walk into a court and just sit there and watch, right? So if you go down to your local courthouse, whether it's a district court or a justice court, like if it's a municipality court or someplace like that, if you were just to walk into one of those courts and sit there and just observe the cases as they come through, I would dare say out of 100 cases that come through that court, 100 of them are courts are being prosecuted administratively in courts of equity,
Yeah, yeah.
100% of the time.
With the exception of the big
Because
crimes of murder and some kind of assault, then yeah,
e-
they're gonna do it the
even still,
easiest path forward.
they're going to take the path of least resistance, right? So you've heard the phrase "a simulation of legal process," right, Gary? You've heard
Yes,
that?
sir. Yes, sir.
Okay. So let's take that example you just mentioned there. Let's say you're being accused of capital murder, murder one, murder with. I mean, you had premeditated. I'm going to kill this guy, and this is the date and the time I'm going to do it, and you've been arrested for it, and you're being tried for that particular crime. What is the process supposed to look like from the time you're arrested to the time you're convicted? Let's walk through that process so everybody knows and understands. What's supposed to happen is this. Let's say, for example, a police officer just happens to be in the area and he sees you shoot someone and you kill that individual and you did it with malice and intent. We'll set that into the side for a minute. Officer sees you do that. What do? They tackle you, they disarm you, slap handcuffs on you, and they take you off to jail. So typically what happens from there is you sit in jail for anywhere from 24 to 48 hours. Sometimes it's longer depending on the state. And then what happens? You have what's called an arraignment hearing, right? You ever hear this, Gary?
Absolutely, you're right on track.
Okay.
Although usually
Okay.
the officer
In the
doesn't
arraignment,
witness the crime.
exactly. Okay, so in the arraignment hearing, the judge comes and says, "You're being accused of killing so and so. Because this is a capital offense, I am not going to allow you to post bail. You're going to sit in jail until we hold your trial." Then we go through this whole process, and let's just stop right there. Let me ask you, Gary, is there anything wrong with what I just described? This guy is guilty as all will get out. Two or three other people witnessed it. He killed this other guy in cold blood. Is there anything wrong with the process that I just described to you?
Did the witnesses sign affidavits or complaint?
So you're on the right track. And this is one of the things that you're going to realize when you start listening to other individuals who understand what proper due process of law is. And when you start reading your state's constitutions, or even the federal constitution for that matter, you'll know and understand anyone who is accused of a capital or otherwise infamous crime. We see that in the federal constitution. You have a right, okay? You have a right to a pretrial hearing, not not the arraignment. We're going to go even before that. What have we often heard those hearings called? Well, those hearings are supposed to be called a probable cause hearing. Have you ever heard of that before, Gary?
Sure. Evidentiary hearing, things of this nature.
Similar. Yeah. So what a probable cause hearing is this? And you're going to notice when you look up in your state statutes, typically you're going to find a statute that says something along the lines of when an arrest is made without a warrant, whoever is arrested must immediately be taken to some magistrate, which is typically a judge, either the judge that's in the area in the jurisdiction where the crime, allegedly happened, or if a judge isn't available there, take him to the next available judge. And then all of the probable cause evidence is to be given for a determination. Yes, Mr. Officer, you had probable cause to arrest this individual, put him in jail. Let's schedule the arraignment hearing. That's what's called a probable cause hearing. Anytime anyone is arrested with or without a warrant, the Constitution and the common law requires a probable cause hearing. I'm here to tell you guys, 99.9% of the time, it never happens. Never happens. So
No,
what happens
because
to this individual who's being accused of capital murder? Sorry, go ahead, Gary.
no, of course, it's the police officer's word good enough. They can now sign trespassing
Yep.
complaints on their own, even though it requires the owner to be there, and they just allow this to roll through the court, and it's been going that way for as long as we can remember. So it must be right.
Exactly. Oh, it has to be right, right? So what happens if you get into court and the court says, "Oh, well, Mr. Brown, it looks as if you're being accused of murder one, and you're in an arraignment hearing today, and I see you don't have counsel. Can you afford counsel, Mr. Brown?" And you go, "No, I can't afford counsel." Okay, the court's going to appoint you counsel. Court appointed counsel,
Great.
another member of the association that not only the prosecuting attorney is a member of, but 9 times out of 10, the judge is a member of it, right? So you're expected to get a fair, honest defense from this guy. And you sit there, and what's the first thing this guy does? Well, the statute says this, the statute says that, the statute says this, and the statute says that. Do they ever talk about any of your constitutionally protected rights? Seldom,
No,
if ever.
no.
Yep. Very, very rarely happens. Very, very rarely happens. So, this is the world that we live in. What this court is, and this is what I'm talking about, the overall theme of this recording today is a court at law versus a court of law. A court of law, just like of denotes, is something that was created by it or for a specific purpose. So courts of equity, you've heard this before, right? So typically, if I'm suing someone and I want the court to grant me equitable relief, basically it means I have a contract and I'm suing someone because that individual did not adhere to the terms of the contract. Now I'm seeking the court's intervention to grant me the equitable relief the contract says I am entitled to. Anything wrong with that statement, Gary?
Not that I can see.
Okay. Makes sense, right? So what happens when and you've got a great example of this. You were riding your motorcycle down through the city of Central, and you got some guy who decided you were going too fast. He flips on his lights and he pulls you over and he gives you a ticket. And then he says, "Well, you weren't driving using a license or a license plate. So the statute says I can impound your motorcycle." Isn't
That's
that what
right.
happened, Gary? Do
That's
I have that
exactly
right?
right. And the Fifth
Okay.
Circuit let them do it.
Okay. And the Fifth Circuit let him do it, right?
Hmm.
So when we look at these things, we have to know, are we making the arguments at the right time? So when you read the statutes, I mean, we've all had this discussion. I know you've talked with this at length. I know that Brandon has talked about this at length. Alphonse has talked about this at length. The statutes are written with specificity for a reason. They are to apply to a general purpose described within the language of the statute. So, for example, if it says if you're driving a commercial semi truck down the road, you must pull over into the scales if your truck is loaded with iron, barley, hay, whatever else it might say.
Or in commerce.
But what about trucks that are driving down the road empty? Exactly. What about trucks that are driving down the road empty? Well, the
Well,
statute doesn't say I have to pull over if I'm empty, right?
I
So
don't
if I
know.
keep driving by that scale house, what's going to happen? They're going to track me down. You didn't obey the sign back there that said all trucks must exit. Well, wait a minute. I read the law and it said only if I'm carrying goods in my trailer am I required to pull over. The same is true in all of our situations. So, what these courts at equity are doing, essentially, they're enforcing contracts and they're instituting penal clauses of those contracts. So, I guess the question that I have, and if I ever end up in one of these courts, this is the question I'm going to ask and say, hold on a second here, Judge. Is this a court at equity? Yes, it is. Okay, great. Where's the contract that this court is enforcing exactly? Can I please see that?
I, I
Can I inspect that, please?
I think it might be better to explain it that the municipalities and sometimes the state are misapplying the statutes to unapplicable people, right? Rather than
See, well, you're absolutely headed right down the exact path you need to be going, Gary. The municipalities and the states and counties and the police or whoever else it is, they believe and they have been indoctrinated to believe that everyone must have one of these contractual agreements in order to operate their motor vehicle or to be able to do certain things. They have been told that. And if you don't do this, you're violating a law. And if you're violating that law, you're being held criminal and blah 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 blah.
I'm a
But here's the
little
problem with that, Gary.
I'm a little uncomfortable with the term contract in the I get what you're
Okay.
saying. I
Well,
understand it, but I don't want anyone else out there to misunderstand.
don't get me wrong. That's what I'm saying. Don't don't misunderstand what I'm telling you, because again, essentially these courts are enforcing a contract that doesn't exist. That's what I'm saying. There is no contract, right? So if you march on down to the local Department of Motor Vehicles and you fill out an application to get a driver's license, generally speaking, there's some type of a verbiage on that application that says, I agree to adhere to all traffic codes and blah, 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 blah. So it is what we would typically call a quasi contract. You ever heard that term, Gary? Quasi contract? You heard about
Yes, I
that
have.
before, right?
I have. And
Yeah. Okay.
I want to take a moment and think about this for a second. So
Sure.
it's not that they're forcing a contract on you. It's that you
Correct.
applied for a license, and
Correct.
that license applies for those traveling in or driving in commerce, which means be
Correct.
it a taxi, hire people. You're transporting people
Hmm.
or goods for hire. And so under
Exactly.
those laws, they have convinced all of us that we need that driver's license, that inspection sticker,
Correct.
and I do
Correct.
think there's some discrepancy in state law about having a tag or not. I think you need a tag, whether it be homemade or by the state, regardless. So let's be careful there
Hmm.
on all that. But do continue.
Yeah. No, you're absolutely correct. I mean, that's the The Supreme Court has stated, and I always go to the Supreme Court because whether we like it or not, that's it. What the Supreme Court says goes. Okay. They're getting much better with their rulings, as you guys can see. They got rid of horrible rulings and horrible precedent that stood for 40, 50 something years. We're seeing good things coming.
Sure.
But whether we like it or not, what the Supreme Court says is the way it is. And time again, the Supreme Court has ruled no license is required to travel the highways and the byways and the roads of our country. That is a fundamental right that we, the people, have. God gave us two legs for a reason. He gave us brains in our heads for a reason because we're smart enough to use those and figure out ways that we can go see loved ones or go see the great world that God created for all of us to enjoy. But see, the problem is that you've got corporations and governments that are saying, hey, we can monetize this. We can make money from this. We can steal money from people, make them believe that they cannot drive on our roads unless they have that little piece of paper or that little tag that says driver's license, make them believe that they have to do all of these things. We can continually and perpetually tax their private property. Have you seen that, right?
Yeah.
Most state constitutions.
And a lot of people watching have watched Jimmy Jones talk about his situation. And it's very, very much the same. And I would encourage anyone that didn't to go back and listen to that.
So every state's constitution, I have not found one yet, but usually in the first article, which is the Declaration of Rights for your state's constitution, it says somewhere in there that every person in that state, every man or woman, has a right to acquire, possess, and protect property. United States Supreme Court in Murdoch versus Pennsylvania stated that a citizen's right cannot be converted into a privilege, and the state cannot charge a license and a fee for it thereof.
Right.
Okay, so if I have a right to travel, the state cannot convert that right into a privilege, right? How many times have we heard road pirates that wear badges and guns tell us driving is a privilege?
That's right.
You don't have a right to drive. That's a privilege. Driving's a privilege. Well, I mean, if we're going to start talking about legal definitions in terms of what the word driving means, maybe you're correct there, Mr. Officer, because generally speaking, a driver, when I look up the legal definition of what a driver is it someone, and I quote, who drives a carriage of horses for hire. That term has not changed.
Right. Driving is a commercial term.
Exactly. It's a commercial term. Well, hold on a second, Mr. Officer. I'm not driving. I'm using my personal vehicle to go from point A to point B. I have a right to do that. This is my private property. No, the state has convinced him and everybody else you must pay a fee every single year to continue to operate on this road unless you want to be hounded and harassed, which, Gary, you know firsthand.
That's a fact.
Okay. So that's a fact. So what I want people to understand is in essence, what's happening is you're being prosecuted, whether they call it an infraction or a misdemeanor, for a quote unquote breach of a contract, because that's the only way it withstands constitutional scrutiny. Because again, the Supreme Court has stated that no, the traffic laws and all of those infractions that go along with the traffic law are 100% constitutional. And here's the caveat: if you volunteer to agree to it. Everything that we do, everything that we're thrown up against is because we unknowingly volunteered to do it, and we didn't even ask why.
A fairly easy.
Didn't even ask. Wait a minute.
Go ahead. A fairly easy argument.
No, you're fine. Go for it.
In the Supreme Court chambers, it's not an easy argument.
Exactly.
On the side of the road with the guy with a gun.
Exactly. And that is not the place to have that argument, ladies and gentlemen. I'm here to tell you, 10 times out of 10, you're going to lose that argument if you're trying to convince that road pirate on the side of the road. Well, the Supreme Court says I can do this. Supreme Court says I can do that. They don't give a flying rip because their sergeant or their lieutenant or their captain has said, no, you will do what we train you to do. Your constitutional rights be damned.
That's why they were hired.
Okay. That's why they were hired. Exactly. And I worked with law enforcement. I still do to an extent. For the last 6 years of my life, I've been blessed to work with the good men and women who get into law enforcement because they want to help people. They don't get into law enforcement to violate people's rights, but because they have been horribly misaligned and mistrained by their superiors, they do it on a daily basis.
And
They
in
think that they're
particular,
okay.
the municipalities.
Exactly. They have, again, the creation is attempting to overthrow the creators. We, the people, created the government. The government has decided, oh, well, geez, I kind of like this power. I like being called mayor. I like being called congressman. I like being called senator, right? Look at all of this power and look at all these people keep coming to me and giving me money, asking me to pass certain laws that'll help them benefit their business. Man, I like this. Let's keep going. This is the problem. The Supreme Court has also stated that every statute that is passed is presumed to be constitutional until and unless it's challenged. But how easy is it to get a case in front of the Supreme Court these days, Gary?
I'm gonna go with pretty tough.
It's darn near impossible. But there is something that's interesting, and I'm trying to find it here. I was listening to this earlier this morning. The Supreme Court actually has, okay, here it is right here. The Supreme Court stated in the case of Ashwander versus Tennessee Valley Authority, there are 7 questions the Supreme Court will apply to any and every case that comes on a petition for a writ of certiorari. They're going to say, does this case meet these 7 questions? If it does, this is probably something we should take up and we should hold a hearing and we should issue a ruling on. So the very first is whatever statute it is that you're challenging, there must be an actual controversy before the court. So what do I mean by an actual controversy? There was a gentleman during the time of these recordings that I was listening to from George Gordon, who in Illinois wanted to challenge the constitutionality of a gun restriction law that the Illinois state legislature passed. The problem is that he was just challenging the constitutionality of the statute. He wasn't physically harmed or damaged by that statute. He
But
just wanted to challenge it.
but
So
did it chill his rights?
that he couldn't prove that either. And that's what I'm saying. He couldn't prove that it chilled his rights so much so that he dared not to do that for fear of what the retribution would be. He couldn't show that because, again, this is back in 1984, 85, something like that. So when he tried to challenge that all the way to the Supreme Court says there's not an actual case or controversy here. You're not showing how that statute damaged your constitutionally protected right to keep and bear arms. So this isn't a case that we need to adjudicate. So the very first thing that we need to understand, if we're going to take on this fight, and this is the fight that I'm in right now, and I know Gary has been down this road, unfortunately, with the Fifth Circuit of Appeals. And brother, if you and I want to talk about that, I'd love to talk with you about that later off air.
Sure.
But we need to show, wait a second, the statute says if I carry a driver's license, then I must adhere to this. I wasn't carrying a driver's license. They're misapplying these statutes to me. I have an actual controversy because they stole my property absent my due process rights. Well, the district court said that they could do that. The Court of Appeals said that they can do that. I'm contending to the United States Supreme Court that they cannot do that under a petition for a writ of certiorari. And if there's any case that's primed for that, Gary, I'm telling you it's yours. I'm just saying. Okay?
Brandon and I have talked about this, and I just don't think with the docket that they have these days, being the Texas, all the election stuff, that it's really going to be worth pursuing at this point. But
yeah, because here's the problem, right? How much is it going to cost for little old pro se Gary to file for a petition or writ of certiorari?
Well, $300.
I mean, that's the problem. Yeah. So it's not terrible.
No.
It's not terrible, but
it's less than the appeals.
It's all the time. That's crazy to me to think that it's only $300 to go to the Supreme Court where the appeals court was over 600. That's
Fi-
insane.
505. 505.
Okay. So the Supreme Court has said that they're not going to give advisory opinions on whether or not a statute is constitutional or not. There must be an actual case of controversy where you're saying, I have been physically harmed by this statute and its misapplication towards me. So that's the argument that I'm getting ready to put before my court of appeals in my case. Now, in my case, I sued my local county tax collector for, dude, I own my property privately. Why are you taxing me with a commercial tax? I don't do any business here. Oh no, everybody gets taxed. That's the right. That's what's being told.
Yeah.
Oh well, we have a, and this is what just boggles my mind is the state Supreme Court where I live here in Utah. They have said that there must be a tangible or physical nexus between the entity seeking to impose a tax and the person or thing that they're seeking to tax. Gary, what's the definition of tangible?
Physically, you can physically touch it, put it in your hands, and let's
I'm
go
holding a
back to
pen in
the
my hands for those of you who are watching.
and let's
Exactly.
let's
I'm
review.
holding a pen in my hand. Go for it.
Yeah, let's review. There's only three taxes allowed by the Constitution: impost, excise, and
Okay.
duties. All three, by definition, are commercial taxes. So, how are they taxing the private individual?
Yeah. They have pulled the wool over your eyes and made you believe otherwise. So what the Utah State Supreme Court was saying, because I have a provision in my state's constitution that says all persons and property shall be taxed uniformly at this thing, right? So that it's our property tax provision. But see, the founders of my state never in a million years ever would have thought that they'd have to clarify that to mean, oh, this is only people or creations of the state. They never thought they'd have to do that. So this Utah State Supreme Court said no, this provision only applies to a taxing authority that has a substantial or tangible nexus. A substantial or intangible nexus. I mean, there has to be a connection between us. Well, what's that connection? Gee, I don't know. Articles of incorporation, operating procedures, business tax income returns. Do you see where we're going with this?
Yeah.
When none of those things exist, well, they say, well, you bought your home within the geographical boundaries of our county, so we can tax you. That's the tangible or substantial nexus. You didn't own the property that I bought. But see, the wool is pulled over our eyes because guess what I found out, Gary? And I didn't know this when I bought my property. So here in Utah, and it might be the same in Louisiana or whatever state you're in, generally when property changes hands, when I say property, I mean real estate, real property. When it changes hands, the seller will convey the property to the buyer through some type of a warranty deed. It's either a special warranty deed or a warranty deed where they're guaranteeing, hey, you're going to get the property. We're going to insure it against any future claims. That's what the title insurance policy is for. But guess what is written on that special warranty deed? Subject to general property taxation.
Yeah.
Whoa.
Benny
Wait a second,
brought this
Gary.
up.
Wait a second. Why, if the state can lawfully tax every piece of property within its geographical boundaries, why in the world would that line need to be on my special warranty deed? Why does that have to be there? We go back to what we just talked about, right? The Supreme Court has said that's absolutely constitutional if you agree to it.
Right.
It doesn't mean that you agreed to it willingly, knowingly, and willfully. It just means, well, you signed your name
agreed.
on the line. There you go. That's right.
Yeah.
Do you guys see how shady this is, how devious all of this is, and why it just gets under people's skin?
And it comes back to
This is why
what you
we
said
have
it
to know.
at the beginning, which is if you aren't belligerent in your rights and know how to defend them,
Mhm.
you won't have any.
You don't have any. That's right. So now knowing what we know now, and now that I've over the last 4 almost 5 years that I've been on this journey that I call my legal reawakening, if you will. I am adamant that I'm teaching my kids. My oldest child is 17 years old. She'll be 18 the end of this year. So she's going to be an adult in this society, which, first of all, sickens me to death. I cannot believe I have an 18-year-old, soon to be 18-year-old. But she's going to be an adult in this world, and she's going to have to know how to navigate these waters that we're trying to navigate on a daily basis. So if she doesn't know she has a right to own property free and clear from anyone bothering her, if she doesn't know that she has no legal or lawful right or presumption that she has to pay taxes on her labor, your labor can't be taxed. You have a right to your labor. Your rights cannot be taxed, but we have all been duped into believing that you have to. That's not how this works. We go along to get along, right?
But
We're
it
good
is
little
how it
citizens.
works
We
right
just want to
now.
be left alone. Right now,
Mhm.
I really hope that there's a great awakening, a second or a third great awakening coming, and I'm hoping it comes this year or next year. And I'm not trying to tie this into any political events because I don't care. I mean, what those idiots in Washington, D.C. say or do, it means nothing to me because it doesn't do anything for me personally. I need to fight the fights I have to fight, and those fights are here at home. I don't
Well,
care
look,
about what happens in
I,
Washington, D.C.
I agree with you, except that we are now dealing with the judiciary that was appointed by Washington that are
There you
judicial
go.
activists. And so we have to care
Yep.
about all of it at this point because it's been all so corroded and eroded away that it takes the Supreme Court to hear every case to properly adjudicate.
Hmm.
There's a few out there
Hmm.
that'll do it, but not many. I don't have one of those judges. I mean, I think Tate might, but I don't. I'm not sure you do.
Yep. I mean, that's what I'm saying is all I know is according to Ashwander versus Tennessee Valley Authority, the Supreme Court has established, and we can go look up this case. The Supreme Court has established 7 rules that it uses in determining whether or not they're going to docket a case and they're going to listen to it and rule upon it. So, if I know what those rules are ahead of time, can I properly get my proceedings in front of the court as long as I know I'm asking the right questions at the right time? That's
And
something else I think is fascinating. If we're not asking the right questions, you might get the answer to the question you're asking, but maybe it's not the right question you should be asking. I mean, if I
true.
go into the Supreme Court and I say, "Hey, court, can the state tax my property?" Sure, they can. Is that the right question I should be asking? No. The question I should be asking is, "Hey, Supreme Court, can the state convert my private property to a commercial property and attach an ad valorem tax to it and send me a tax bill and treat me as though I'm a taxpayer without any evidence that I am a
Bing-
taxpayer?"
Bingo.
Those are the questions we need to ask. Because whether or not it's been decided previously, I mean, see, here's the thing: the Supreme Court wants to avoid relitigating issues, right? That goes down to this doctrine we've heard of called res judicata. You guys have heard of this before, I'm sure. If any of you who've been following any of the things that Gary does, or that I do, or that Brandon or Alphonse does, or anybody, Dave Merlin, there's too many people to name. But if you've been following any of the people like that, you know what res judicata is. Courts are not going to relitigate an issue over and over and over again. But if it's a big enough issue and it's affecting the majority of the people in this country, by golly, is there a bigger issue than property taxes right now? Maybe income taxes, but that's something we can tackle another day. Can
Speeding
a
tickets,
private organization,
citations.
a semi, right?
Just saying.
So there's so many. This is what I'm saying is there's so many questions that we have to ask ourselves. But this is some. I gave my county every opportunity to try and settle this with me. They said no, we're going to get the case dismissed. Okay, that's what you guys want to do. And guess what the stupid magistrate judge did in his opinions? And I went through this on my podcast last week. So for those of you who may not know my podcast, it's on YouTube. Search The Justice Revolution. You'll find it there. I'm on all of the podcasting streams as well.
I'll leave
But
a
I went
link in
over
the
the
description.
oh, thank you. So I went over the magistrate judge's ruling, and he, on multiple occasions, referred to me as a taxpayer, told me that all of my assertions that are in my complaint that I am not a taxpayer, and I'm quoting, the plaintiff's arguments fail. That's it. My arguments fail.
Well, they don't
I mean,
they don't
I don't know
teach
why
law
they
in law
failed.
school anymore. So
No, no, they don't. No, there's no
that's a
such thing as,
perfectly valid
findings of
answer.
fact and conclusions. Exactly. There's no such things as findings of fact and conclusions at law, Gary. The plaintiff asserts he's not a taxpayer. However, the record shows that he paid taxes on such and such day and he filed a tax return with the county on such and such day. The evidence suggests otherwise. No, no, none of those things. Because number one, that evidence doesn't exist.
Right.
But everybody's a taxpayer. So you're a taxpayer because I said so. That's actually the title of the show that I did. You're a taxpayer because I said so.
Right.
So the point that I'm trying to make here, the point that I'm trying to make here is that unless we are a belligerent claimant of our rights, unless we are putting the right question in front of the right people. So here's where I'm at with my case. I'm headed to the 10th Circuit Court of Appeals. In my complaint, I cited a ruling from the 10th Circuit Court of Appeals in 1946. The case is Adler versus Nichols. And in that case, the Court of Appeal stated, and I'm paraphrasing because I don't have it in front of me, but they stated it is equally well settled that the revenue laws relate only to taxpayers. And there is no procedure prescribed in law for a non taxpayer to recover funds taken from him under the color of law. Oh my gosh. Isn't that what I just argued? And I got a stupid district magistrate judge who decided, nope, this doesn't apply. He didn't even refer to that case in his order, his memorandum and order. So when I go to the 10th Circuit Court of Appeals and I say, this very court has stated the revenue laws relate only to taxpayers. The defendants have produced zero evidence that I'm a taxpayer. I have asserted under penalty of perjury, I am not a taxpayer. Okay, so have I properly positioned myself? Have I properly made my position clear to the court that it can rule on it accordingly? I think I have. So what am I expecting? Am I expecting that they're going to overturn this decision and send this back and remand the case for further proceedings? No. Expect the worst, hope for the best. I'm expecting that they're going to affirm the decision. So now I am properly setting myself up to get in front of the Supreme Court. And I'm not even guaranteed or hopeful that the Supreme Court will, one, take the case, and two, if they do, actually rule correctly on it. Because can you imagine the storm and the windfall that will come as a result of this? And I'm only one guy. What happens if Alphonse's case gets in front of the Supreme Court? What happens if anybody else who's attacking the property tax system in this country gets before the Supreme Court? You guys see the effect that could potentially have?
Well,
So
yes, and I think that
this is why I do what I do. This is why I Sorry, go ahead, Gary.
I think we do see the magnitude of that, and I think that some people might be scared of the consequences of what that may bring when you take that much money away from government. The services are going to necessarily go away, and that's something we should all be prepared for.
Well, here's something I want to clarify for everyone, and maybe you knew this, Gary, maybe you didn't. But the big misconception, the big lie that we have all been sold, especially as it relates to our property taxes. If we all stopped paying our property taxes, all of us non-corporation people, right? Just everyday Joe Blows, they have their family, they have their house. If we all stopped paying property taxes, there'd be no money for schools, there'd be no money for roads, there'd be no money for police and fire and all these things. That's what we've been told, right? Is that what you've been told, Gary? Have you heard that before?
I've heard the argument.
Okay, you've heard the argument. That is a bald-faced lie. And here's why. There is more than enough revenue generated from the sales tax of goods and services to fund the entire government twofold in each state. When I say government, I'm talking schools, I'm talking police and fire services, I'm talking anything else that goes to the general welfare of the public. There is more than enough money from the sales tax on goods and services. So, what would happen if we stopped taxing people into oblivion? Well, they'd have more money in their pockets. What do they do if they have no more money in their pockets? They spend it, usually, because we're stupid. We don't save money. So, if I have more money and I go out and spend it, I take more vacations. I go to California or I go to some sunny place in Florida to take vacations. Well, now they're getting sales tax revenue from me and from my hotel, from my travel, my food, and all these other things. It's just, again, it's a snowball effect that it just continues to get bigger and bigger and bigger, and ultimately more and more revenue is generated. But no, the government bureaucrats have decided that because we can do what we want to do and we're going to do it this way and this is how it is, and you will get in line and you will obey and you will be a good little serf on the land and you will not question your authority because we are in a position of authority. And how dare you question authority? No, we give you your privileges and rights. You
Well,
don't get rights and privileges from
and
God.
and it's also an effort, not it's an effort for control, but it's also to prevent you from traveling, because as Mark Twain said,
Correct.
travel dispels prejudices. And if,
Yeah, it
if
does.
you know, I've been in 22 countries, and it changes you. It will change you, and I think that that's what they don't want to happen, because they discourage travel to
Yeah.
Mexico, even though it's cheaper and a lot nicer in a lot of areas. And so they try to keep you
Mhm.
home and tuned into that idiot box, so that they can keep the programming going, tuned into the same food, chemicals,
Yep.
whatever you want to dispel there.
Yeah. I mean, you're absolutely right. And this is why I'm saying it's crucial that we take the time to do the research, to craft our arguments accordingly, so that we can ensure we have set our case up properly for adjudication by the Supreme Court. So I've already mentioned one of the rules that they state. There's 7 rules. I've got a couple of others that I found. I'll touch upon. So the second rule, according to that case, um, is the Supreme Court will not anticipate a question of constitutional law in advance of the necessity of deciding it. So what does that mean? It's like, well, I have a question. Is this constitutional? It's a hypothetical question. Is this constitutional? Let me take it to the court and see. Is there an actual case or controversy before the court? No, there's not. They're not going to. There's why we need to waste our time. That's exactly what they're saying. Number 3, the court will not formulate a rule of constitutional law broader than is required by the precise facts to which it is to be applied. They are going to answer exactly the question you ask and nothing more and nothing less.
Well,
Okay.
sometimes
They're not
less.
going to expound. Sometimes it's very less, right? We all heard about this case maybe it was this time last year or earlier than that. I can't remember. It was the Brunson versus Adams case. You ever hear that case, Gary?
No, I don't
Brunson
think
versus Adams?
maybe if you refresh my memory.
So it was actually a guy here in South Ogden, Utah, where I live. It's like 20 minutes from where I live. He sued all of the members of Congress, and the case was dismissed in the district court for lack of standing. The case was dismissed in the 10th Circuit Court of Appeals for lack of standing. He petitioned it to the Supreme Court. The Supreme Court declined to take the case. Can you take a guess why? How was he physically harmed by the actions or the inactions taken of the members of Congress? You
I can
must have standing. You must be able to prove you have standing to bring those claims, and he couldn't do that. That's why the
what
Supreme Court declined to hear his case.
I see where you're getting, but when a member of Congress, or at least the majority, vote combined with the president's signature, they could absolutely harm you.
They can, right? So let's say that they come in, let's say that they pass a wholly unconstitutional law that every law-abiding citizen should be disarmed. Can they pass that law? Sure, they could pass that law. That law can go into effect tomorrow. But what happens if me, as one of the law abiding citizens of this republic, I'm constitutionally carrying my firearm to protect myself? I'm unlawfully disarmed, I'm thrown in jail or whatever else. What happens if I take that case all the way to the Supreme Court and I say, hey, Supreme Court, Constitution says I have a right to carry, to keep and bear arms, and that right shall not be infringed. I believe that my government infringed on my right to keep and bear arms when they passed this law. Is this law constitutional? Have I properly presented my question before the Supreme Court? I would say
Absolutely.
yes, because I am aggrieved.
Right.
I'm aggrieved by that law.
Mm-hmm.
But what happens if Congress passes this law and I'm like, that's an unconstitutional law. I'm going to challenge that. So I challenge it.
Well,
And it gets all the way to the Supreme Court. And
this is what is interesting about Tate's case, right? He is alleging that his right to assemble was chilled and deterred by the fines in place by the city council, and it's moving forward.
mm-hmm.
So this will be interesting to see, but a chilling and deterring effect
It'll be interesting to see, right?
Is very much a harm. So we'll see what happens.
It is. If you are, and if you can properly present that question before the court, if you can properly say, hey, had I done this, I would have lost my right, I would have lost my liberty, I would have lost my freedom, I would have lost my property. All of these things would have happened to me, which would have been horribly detrimental, to which no restitution could have been made. You can make that argument, and if you can make that argument successfully, then absolutely you've got standing to bring that before the court. I believe that Tate is doing a great job of that. I really do.
When
I'm reading his pleadings, he's just like all of us. He's gotten so much better.
Oh,
right? I look back on the first lawsuit I wrote, and I'm like, I was a freaking idiot.
We all
now
were.
when I write a lawsuit, I'm like, okay, yeah.
We all were.
Now when I write a lawsuit, I'm like, okay, I actually have a better understanding of how to contextualize this and to put things in the right context. So that's so that was rule number 3. So rule number 4, the court will not pass upon a constitutional question, although properly presented by the record, if there's also present some other ground upon which the case may be disposed of. If they can get away, if they can dispose your case without ruling upon the constitutional question, they're going to do it. I mean, as sad as that is, look at the decisions that have come out recently. You can see that they're going to find other reasons to get rid of those cases.
Yeah, and the Fifth Circuit in the city of Central, just so you know, they ruled it time barred, so they didn't have to answer all that questions.
Yep. Okay. So, do they have a constitution? I mean, did they violate your constitutionally guaranteed rights? Absolutely, they did. But why did they dispose of your case? Oh, it was barred by the time limits.
Yeah.
Do you see how asinine this is?
Because it's real easy to learn the federal court system and write a complaint in under a year. Very easy.
Yep. Okay. Here's rule number 5 from the Supreme Court's 7 rules of whether or not they're going to take a case. The court will not pass upon the validity of a statute upon complaint of one who fails to show that he is injured by its operation. This is what we're just talking about. You must be able to show you've been injured by the operation of that statute or properly plead the chilling of your rights as a result of the passage of that statute, like Tate has been doing. Okay. So it says here is like when you're driving on the roads with a driver's license, well, you just better shut up and obey the law. If you pay the income tax, if you have income, pay the income tax and obey the law.
And when was
basically how it is?
This case come out with these lists? When did this come out?
I don't have the actual here. Let me see if I can pull it up and tell you. So it's
you tell me the name, I can.
Oh shoot. Gosh dang it. And I can't remember it either. It was Ashwinder or something like that. Let me pull up my case. I'm going to log into Westlaw and see. So, rule number 6. All right. So the court will not pass upon the constitutionality of a statute at the instance of one who has availed himself of its benefit. So he brings up this, George Gordon brings up this thing. He says, I once had a judge tell me not long ago, he said, why don't you go out and get a driver's license? And why don't you go register your car and buy insurance? And he said, well, if I did that, I'm not being damaged and injured by the statute, am I? I'm availing myself of the benefits of the statute. And that's, of course, what everybody who's subject to the civil law should not do to subject the civil law to the higher powers. Okay. And then the last one, rule number 7, when the validity of an act of Congress is drawn into question, and even if a serious doubt of the constitutionality is raised, it is a cardinal principle that this court will first ascertain whether a construction of the statute is fairly possible by which the question may be avoided. Excuse me, by which the question may be avoided. Isn't that statutory construction? Isn't that what we just talked about, Gary?
Yeah, and I think the court might need to revisit some of these 7 rules.
I would agree with that. Let me see if I can find it. Ashwinder. I think that's what it's called. No. Ash, oh shoot. Let me see if I can look it up while we're talking here. I just had it, but I can't remember where it is.
I'm in Westlaw.
But yeah, I agree with you. I think some of oh, here it is right here. Ashwander. ASHWANDER versus Tennessee Valley. Here it is right here. 1936.
Yeah, that sounds
The
right.
United States Supreme Court issued this in 1936.
Yeah. So that
Okay.
might need to be challenged.
Yeah. So, and here's something else too that I think we can help people on that may have, if you have a subscription to Westlaw, or so I had a subscription to Case Text. Well, Thomson Reuters, Westlaw bought them, so now I have that. When you pull up cases here, sometimes you'll see these little warning labels. You've seen those before, right, Gary?
Sure.
Where it says warning, this case has been cited in contradiction and things of that nature. Pay no attention to any of that. If it's a United States Supreme Court case, the only thing you need to be concerned with is, was it overturned by another decision by the United States Supreme Court? That's all you need to worry about. Everything else can go out the window. Who cares? I don't care. Like in this one particular, it says warning, it was cited in contradiction by the District of Columbia. I don't care. District Court of Columbia. I don't care. This is the United States Supreme Court. I don't care. Okay, so this is where you're going to find those 7 rules according to United States Supreme Court. Things may have changed between then and now, but this particular case has not been overturned since 1936.
And if it'll allow me, I'll put the PDF and the links too, so people can read it.
Yeah, you should be able to put a link into Google Scholar.
You can all get into Big Sib Chat, Telegram, and all of these things are posted there.
Yep. So anyway, I've talked your ear off enough. My gosh, here we are. I can talk for hours upon hours.
Sure. No. And we appreciate it. But we'll regroup
I said,
and do a different topic next time, and
okay.
Do all that.
All
and
right. I love it. Thanks for having me on.
Yeah, I'll probably have a few suggestions for you next time, and maybe we can, instead of just giving you aimless direction from my end. It's just been crazy trying to get all this thing started. So I appreciate you coming on.
I know.
And I'll give you the last word.
Thank you. No, I just want to say thank you for inviting me. Always love talking to you. Always love talking to Brandon. Always love talking to all of our brothers and sisters in this fight to keep our rights. I mean, let's just remember, you guys, it's really hard to get an adult in the room, even at the federal courts. I mean, gosh, Gary and Brandon know that more than anybody else. I mean, you've got bias. I mean, my goodness sakes, you have discriminatory animus from the Chief Justice of a district court in Louisiana. I mean, how bass backwards can you get? Here's I don't feel point, like we're right? The only ones. I don't think you are. Yeah. No, but here's the thing: is I'm seeing, and this is going to be my final words. So, if you're going at this pro se, like we're doing, the deck is already stacked against you already. Just where they out of one side of their mouth, they say, well, we're supposed to construe these complaints liberally, and we're supposed to not do these things and this and that. But then they throw everything up at you that they possibly can. And the reason why I know this is, look at what happens when someone goes and pays $10,000, $15,000, $20,000 to get an attorney to represent them. Are those attorneys put through that same scrutiny? No, they're not. There is a bias. And I really feel it's because more and more of our brothers and sisters across this great nation that we call home are standing up to the tyranny that's coming and they're fighting back. The powers that be cannot have that. No, 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 no. You have to go get an attorney. You must go get an attorney. I'll give you a good point. Um, I received last Thursday. Somebody came knocked on my door and dropped off a lawsuit. Someone's suing me and my wife over an issue I won't get into. After looking at this, the lawsuit is frivolous, 100%. It alleges the existence of things that do not exist. I could get this thing dismissed tomorrow. Oh, you're alleging that this exists? Well, it doesn't? Then prove it. Oh, you can't prove it? Okay, get this crap out of here. I can do that. So I had a friend, I wouldn't really call him a friend of mine, but an acquaintance who is a practicing attorney. I sent the lawsuit to him earlier today. I emailed him and said, hey, would you be willing to just take this on a contingency basis? Just, I don't have the time to deal with it. This absolutely needs to be fought. I said, I'll handle it myself. I'll just get it dismissed and I'll handle it myself. But there are damages here that I could seek. Do you want to take this case on? He emailed me back and said, no, I'm not going to work on a contingency. And I strongly suggest you don't do this on your own. There are serious legal and blah, blah, blah implications. And I'm like, is he reading the same complaint that I am? I mean, what am I missing here? So then out of curiosity, I said, okay, what's your retainer fee? What do you think that the fee was, Gary?
12,000, 20.
More. Not quite that high. $10,000. $10,000 retainer fee, and he doesn't think that the court will dismiss my case. So I'm not going to go into all the details on it, but the premise is this, is that the complaint alleges the existence of a binding contract between myself and the named plaintiff, which is a company, an organization that I'd never signed a contract with. Not only that, the complaint alleges the contract was signed on a particular date. On that date, this organization didn't even exist. This organization was not incorporated into existence until the following day. So I ask you, Gary, how is it possible that a corporation, a legal fiction, right? Something that we create. So wait a minute, you're telling me that you moved into your house on January 1st, but you didn't start building your house until January 2nd? How does that work?
Well,
does that make sense to you?
No, it does not. And I would think that it'd be a pretty easy 12B to write, but with these judges, you just never know.
It is a pretty easy 12B. It is a pretty easy 12B. But again, because these people, when I say these people, I'm talking these attorneys, because they only know statutory law, they wouldn't know constitutional principles or constitutionality or common law if it slapped them in the freaking face. I mean, what's eye-opening to me is law students who take constitutional law study. They don't actually study the Constitution itself. They study case law.
Right.
Does that make sense? So you're telling me that you took a constitutional law course at Harvard or wherever else you got your law degree from, but you can't tell me what Article 1, Section 5 says? The United States Constitution? I got a clue. You can't tell me what rights are guaranteed under the 6th Amendment? The 8th Amendment? What about the 10th Amendment? I mean, gosh, just the first 10 amendments are the most important. Can you tell me what rights are guaranteed to us as citizens of this country under the
bar
First Amendment?
practices law.
There's 5 of them. They don't have a clue. They don't have a clue. So this is what we're dealing with. So you guys, what I'm gonna leave it with you is this: don't ever give up hope. Just because somebody tells you don't do this on your own, there's a reason why they don't want you to do this on your own. And it's not because they care about you, and it's not because they are concerned that you're going to lose, your property or this or that or anything else. I guarantee that's not why they don't want you to do this on your own.
Facts.
This guy wouldn't have come back to me with a $10,000 retainer fee if he thought that I could get this dismissed on my own without any help. This guy is seeing a dollar sign. He's seeing a paycheck. So because I don't have the time to deal with it, that's where I was at. But anyway, I haven't decided what I want to do with that one just yet. I'm probably just going to file a 12B6 like we're talking about. Because again, if I'm stating a claim for relief that there's been a breach of contract, well, there must be a valid contract between the two parties, between the parties involved, the named plaintiff and one of the defendants. Okay, so produce the contract. Well, the contract is here. It's like, no, that's not the named defendant. That's somebody else. That's not the contract. And this is what these people want you to believe. Oh, as long as there is a contract out there, it doesn't have to be in the name of the named party. It can be Joe Blow, who happens to be a brother or sister of the guy who owns the company. No, no, no. I am sorry, but no. And I will fight that one all the way to the United States Supreme Court, because I'm here to tell you guys, we have an unalienable right to contract that is guaranteed to us in the federal and state constitutions. And you're interfering with my right to contract because you're telling me I made a contract when in fact there was no meeting of the minds. This is an unconscionable contract. And I never agreed to these terms and conditions. And you need to prove that I did. So
In
I'm
theory.
going to leave it at that.
Well, James,
theory.
thanks again.
In theory.
Appreciate everything. And we'll see you again soon, I hope.
Thank you, sir.